As far as sound recordings and work made for hire, there's a couple of issues. One is it's not listed in the copyright law as one of the automatics. There is a provision that says, you know, if there's a signed writing that refers to it as work for hire, but the concept is it has to be in the context of an employment relationship. And a few years ago, I was involved in a litigation. I think it was called Ballas v. Tedesco. It had to do with some ballroom dancers who recorded music and a fight between them. And they sued us in state court, and we removed it to federal court. We said, this is a copyright issue. And the plaintiff's claim was, we paid money for this. We own the copyright. And our position was, you know, you don't own a copyright by paying money. And they counterclaim, you know, their argument was, no, but it's a work for hire. We paid you. We hired you to do what we wanted to do. And in the course of that litigation, you know, the court held that in this case, the sound recording, now again, there was no signed writing, there was no actual contract, there was a bunch of emails back and forth and money changed hands, but the court held that it's not listed as one of the things, and under certain cases that are out there, there's 6 or 7 or 8, you know, thresholds that have to be met, and the most important ones have to do with the employment relationship. And one of the number one ones was, do you pay unemployment tax? Do you supervise and control them on your premises? You know, real employment issues. And the judge found that that wasn't the case. With a recording, that's not the case. I mean, you're not paying unemployment benefits for them. They're not on the payroll, and they're not even working on your premises. They're pretty much doing what they want to do in some other place. So I think that definitely, again, it wasn't a record deal that was being litigated. It was kind of a general agreement. But I think the groundwork was laid for the argument that, you know, a recording artist is really an independent contractor. And for all the reasons that a record label would want the artist to be an independent contractor, that's what they say. You're an independent contractor. We're not partners. You know, we're not joint venturers. But they're not going to pay you employment benefits. So I think if you go down the list of the threshold issues that a court would determine is or isn't work for hire, I think in most cases recording artists making sound recordings for a record label would not qualify. But again, usually the provision says, all right, it's a work for hire, and in the event it's not a work for hire, then it would be an assignment to us. So in any event, the record label would have own the master sound recording copyright. The difference is a work for hire has no reversion right. So if it's a work for hire for Sony Records, they own it forever. If it's an assignment to Sony Records, even if it says forever, after 35 years under the copyright law, you have the right to demand it back. So I think this issue is going to start coming up now because the 76 law became effective in 78. So 35 years from 1978 is coming up in the next few years. And I think that's why it's going to become a hot button issue, because all of the different big artists are going to one by one, starting, you know, from 78 on, begin to say, hey, I'm demanding my masters back. It's the 35-year reversion. And the labels may settle with some of them, but they may not be able to settle or want to settle with all of them. And if they fight them, the first threshold issue is going to be, is this or is it not a work for hire? If it's not a work for hire, then they do have the right to get it back after 35 years. So it's kind of a 1-2 punch for the record labels, having just survived or barely survived the onslaught of the internet and the illegal downloading. They may in just a few years be facing an issue of one by one, all the rights to their masters are going to start to go back to the artists. So they're going to have to dig in and fight it. But again, like I said, based on what I've seen so far, I don't think it's going to qualify as work for hire. So it's going to be an assignment, and it's going to title Blondie and Bruce Springsteen and all those people from, you know, the Ramones and the Talking Heads and all those groups to say, look, I'm demanding back my masters. And either the labels will have to pay some kind of enormous sums or renegotiate with them, you know, to the extent they can, to keep the rights, or they're going to start losing the masters back to the artists. So it's a dilemma that's coming over the horizon.